That is how you make AI useful without making it slippery. A scenario estimate that combines the inference and the assumption. If those collapse into one paragraph, the reader cannot tell what is law, what is inference, what is business modeling, and what has been reviewed. That is dangerous because each object fails differently. The authority can be wrong. The inference can be too aggressive. The business assumption can be stale. The estimate can be arithmetically right and strategically useless. The reviewer judgment can change once the client updates the facts. The platform should preserve the difference between a quoted authority, a lawyer's inference, a business assumption, and a scenario estimate. They may all appear in the same work product. They should not collapse into one voice. A matter board should let a lawyer inspect which parts are source-backed, which parts are inferred, which parts are business assumptions, which parts are scenario estimates, and which parts have reviewer approval. An authority enters as quoted law. A lawyer or system drafts an inference from it. A business assumption attaches to the inference. A scenario estimate uses the assumption. A reviewer decides whether that estimate belongs in the work product. If any one of those states changes, the estimate should update or lose approval. If the assumption changes, the legal authority did not change. If the authority changes, the business model may still be arithmetically correct but legally unsupported. Those distinctions are what keep a legal answer from sounding more certain than it is. That is how you make AI useful without making it slippery. The official number belongs in the primary evidence lane. 0.7% of a fleet-wide resource recovered. The scenario estimate belongs beside it, clearly labeled as a translation, not as a reported fact. If the assumed fleet size changes, the sidebar changes. If the assumed cost per compute unit changes, the sidebar changes. If the operational context changes, the sidebar changes. But the official claim underneath does not magically become stronger or weaker because the sidebar moved. That separation is the difference between analysis and laundering. A good system should make that separation visible, instead of hiding it in polished prose. For a legal team, that matters because clients often ask for the practical consequence, not just the doctrinal answer.